AI and Data Show for the latest updates in AI with host Matthew Holman and special guests Jasprit Kaur and Ben Mailing.
Good afternoon, everyone, and welcome back to the AI and Data Show. My name is Matthew Holman. It's great to see you all. Thank you very much for giving up 45 minutes of your lunchtime to come and hang out with us as we talk about all the latest things happening in the world of tech, AI and data. If you're an in-house lawyer, a private practice partner or solicitor or a DP specialist or just an AI governance person, I say just an AI governance person, you're probably the most important person in the business. And this is the place for you to come and hang out. We're going to try and bring you all the interesting stuff that's happening over the next 45 minutes. In particular, we're going to talk about the Capita fine, very big news in the world of data protection. And of course, we will talk about the biggest case of the year, Getty Images and Stability AI. Now, we're going to start the show with something we started the last show with, which is a quick analysis of what's happening on the continent regarding the EU AI Act, because many of you found this feature really useful. And I'm pleased to welcome back into the studio, Amy. Welcome back, Amy.
Thanks for having me.
Why don't you tell us what's going on in Europe? And I think there have been some changes.
Yes, that's correct. So we now have two more countries in the green list, and these are Denmark and Latvia.
Okay, so Denmark and Latvia are green. Just remind me, there were four
countries.
Four last time.
Yeah.
And there are now 6. So if you are doing anything in the continent where Denmark and Latvia feature in your profile of activities and the thing you're doing involves AI, you need to know that regulators are there. I think it's probably worth also pointing out that much of the map isn't green, is it? It's still
That's right. There's still a bit of a way to go.
Yeah. Very much a patchwork where some countries are still in red and some are in amber. A country that's in red, what does that mean?
So that means they've implemented one authority, but one hasn't even been proposed to their government yet.
And if they're amber?
They have a proposed legislative bill that's kind of waiting to get approved by their government. So halfway there almost. One
thing that this is really good at doing is just illustrating how quickly things can move. I mean, it's been only 4 weeks since we were all last hanging out together, and there have been 2 more countries going from amber to green. So this is a fast-moving picture. We will obviously try and keep you up to date with it. If you want to know more about it, please feel free to reach out to myself or to Amy or the Cripps team. Thank you, Amy.
Thank you very much.
Now, I am thrilled to welcome back into the studio Jasprit Kaur. Jas, welcome back. You were last on the show on the very first show.
It's good to be back.
It's great. I can't believe it's been that long since you were with us. Thank you for coming back. And you have been researching everything to do with Capita. And now most of you watching will know that Capita were fined by the ICO. And they were fined a fairly large amount of money, £14 million, for essentially doing some fairly silly things around their AI security. They were hacked and bad things happened. Jas is going to explore the important things from that case and most importantly tell you how you can avoid similar outcomes. So Jas, over to you.
So, in March 2023, Capita suffered a cybersecurity attack that started when a threat actor gained access to the Capita network following the download of a malicious file onto an employee device. Between the 29th to the 30th of March, the threat actor began exfiltrating data from the Capita network, and this impacted the personal data of 6,656,037 people. By the 31st of March, Capita became aware that it had been subject to a ransomware attack, and it reported this to the ICO. The Commissioner also received 93 direct complaints in relation to this incident. Capita themselves received over 600 complaints, and there's also a High Court multi-party claim involving over 3,000 claimants.
And just to pick up on that last point, that multi-party claim in the High Court is still going.
Yeah.
Yeah, okay.
So what infringements did the ICO identify? Under the UK GDPR, data controllers and data processors are required to implement appropriate measures to ensure that their processing of personal data is secure. The Commissioner found that Articles 5, which relates to integrity and confidentiality, and Articles 32.1 and 32.2, which relates to security of processing, under the UK GDPR, were infringed. Capita plc, acting as controller, was found to be the parent company that was ultimately responsible for monitoring and compliance across the Capita Group, and Capita Pension Solutions Limited, acting as processor on behalf of over 600 organisations that provide pension schemes. The Commissioner found that data had been exfiltrated from 2 entities acting as controllers and 4 entities acting as data processors, and the personal data was found to be contact information, ID information, account information, biometric and signature data, and it also included special category data, which relates to health, medical, sexual, religious, political belief data, and also criminal record information and child data. So a lot of data. So how did Capita infringe the UK GDPR? The ICO's investigation concluded that Capita had breached its obligations by failing to implement appropriate technical and organisational security measures to prevent the unauthorised lateral movement and privilege escalation within a network. Capita did not implement a tiering model for administrative accounts, which allowed the attacker to escalate and move across multiple domains. These risks have been identified on 3 separate occasions prior to the incident, but they were not resolved. The ICO investigation also revealed that Capita failed to respond appropriately to security alerts. It did not satisfy its own service level agreements, and it did not respond to these high-risk security alerts promptly enough. It took them 58 hours to respond to this incident when it was supposed to take them only 1 hour. The Commissioner also found that Capita's security team was extremely understaffed and it fell well below the target response times. The Commissioner also mentioned in his penalty notice that there was inadequate penetration testing and risk assessment. The Commission found that Capita failed to consider the nature of personal data it was processing and the risks associated with processing such data. The systems were only subject to a penetration test upon being commissioned, and they were not subject to any subsequent testing. And the findings of these penetration tests were siloed into these business units, and they weren't extrapolated out and applied across the Capita network.
I'll come back into the room and think about what that means, because if you're an in-house solicitor, if you're a data protection specialist, or if you're an infosec person listening to this, as you may be, then there are a couple of really obvious takeaways from that. The first is that if you feel that your team is under-resourced and struggling, then that's exactly where Capita's team found themselves, right? Also, if you've identified lots of other weaknesses, you've told the business what those are, and the business hasn't done anything about them, then you're in a similar place to Capita. And if you're doing, if you're trying to get pen testing done and it hasn't been done, then you're in a very similar place. Just how significant were these issues in the ICO's decision making? Did it put a lot of weight on this stuff?
Yeah, so these were the 3 main issues that the Commissioner identified as relevant to Capita's breach. So they're really important, and you need to make sure that your business isn't doing these.
And to that end, I would encourage all of you to grab these points and absolutely take the notes from the slides. Use the Capita case as something that you can refer to internally if you're trying to get some traction to get some more staff, or to get some more support on escalating some pretty important IT security stuff. Then this is the time to do it, and this is the case to use to help you get there. Don't be the next Capita. I think you've got some more slides.
I do. So how did the ICO actually go about calculating the fine? So initially the ICO proposed a fine of £45 million. However, having considered the representations from Capita, the ICO and Capita agreed to enter into a voluntary settlement agreement, under which Capita is going to pay a reduced fine of £14 million, and it's also agreed to waive its rights to appeal that fine.
So a 68% reduction.
Yep.
Sound like good value to you?
Yep.
Let's keep going. I'll make no further comments about the ICO, I promise.
So how could this have been prevented? The Commissioner in his penalty notice has set out the following key concepts to help reduce the risk and potential damage following a cybersecurity attack. The Commissioner mentions Privileged Access Management, or PAM. So PAM involves the management and control of privileged accounts. It ensures that administrative access is granted explicitly for a limited duration and with appropriate oversight. The Commissioner also mentions Active Directory tiering, which is a security model that segments administrative privileges and systems into different layers, and the aim is to prevent attackers from gaining access to higher tier systems. The Commissioner also mentions the importance of penetration testing, where there's a simulated cyber attack onto a network to identify any vulnerabilities, and these penetration tests should then be followed by a report which identify any critical high, medium and low risks in the environment. The organisation should then put into place policies, procedures and controls to mitigate these risks. And when a risk can't be mitigated, the organisation should either try to eliminate the cause of the risk, accept it with some contingency plans, or transfer some of the risk out by using things like a managed service provider. So what other practical steps can businesses take? Businesses can follow the National Cybersecurity Centre's guidance on preventing unintended lateral movement of data and files. They can also implement regular monitoring for suspicious activities and respond to initial warnings and alerts in a timely manner. Businesses can implement regular testing and risk assessments and share those findings within the group so those risks can then be universally addressed. Businesses should invest in key security control software such as antivirus, anti-malware and threat detection tools and encryption software, and ensure that this software is actually operating effectively. From an organisational standpoint, businesses should ensure that they've got consistent internal policies, methods and protocols in place with clearly defined responsibilities. And they should also check their agreements with data processors such as IT providers and make sure that these agreements are up to date and that they include the relevant security and information data processing policies. And that's all.
Giles, thank you very much for that thorough review of Capita. It's a really important case. It's really the benchmark for how to go off and argue for better IT security in your business. If you or anyone that you know in your business is trying to get things through and they're struggling to do so, then I would encourage you to read this case. Ultimately, Capita's underinvestment, failure to take the risk seriously and failure to properly resource the team were the things that gave rise to it being fined, even though that fine ended up being massively lower than it probably should have been. Let's move on to the next section of the show, which is all about Getty Images and Stability AI, biggest case of the year. And I'm really pleased to welcome back into the studio for his second stint, Ben Mailing. Ben, welcome back.
Thanks for having me.
For those of you who don't know, Ben is a partner at EIP, specialises in all aspects of IP and software and data, and has particular focus on AI. He is regularly sought out by colleagues and clients for his expertise in this knowledge, and is the driving force behind EIP's Codify service. Ben is someone I've known for a while and is a fantastic speaker, thinker, is erudite and strongly opinionated. And I'm not erudite, but am strongly opinionated. So it's great to have you back. And we will definitely be sparring through some of the issues that Getty throws up for us all. But really, the most important thing for us to do right now is to explain to you what happened in the case. So on the screen, you should hopefully have some slides that will summarize the judgment for you. On the left, you can see a picture that most people will look at and instantly understand to be a Getty image. And it is an original Getty image. It's got the necessary artistic flair and nature to it. It's an unusual picture. And it has stamped across the center the famous Getty watermark. On the right is an image that Getty had nothing to do with. It was created by an AI program known as Stable Diffusion, but it does look and feel like a Getty image. And of course, across the middle is that famous Getty watermark. This is really the essence of so much of the complaint raised in this case. You can understand why Getty were feeling a bit miffed, because clearly the image on the right looks a lot like, or has the same look and feel as the image on the left, because it has the same artistic flair and watermark. But Getty got no recompense at all for its creation. How did that come to be? You're about to find out. Quick recap of who's who. We have on this peculiar legal football field the claimant, which is represented by Phil Fisher, and the 6 companies that make up the claimant listed there. Only one defendant, which is Stability AI, represented by Bird & Bird. It was a massive case, a 12-day hearing with 19 witnesses arguing over various issues to do with different models. And the judgment, which came out just 4 weeks ago, is 201 pages long. Most of you who have known me for a long time will know that I love to study and read cases in depth. I have a collection of cases. It's really weird. I should probably get some help. The cases, I don't think I've got a case longer than this in all the folders I have. This is easily one of the longest decisions that I've seen coming out of the High Court in a long time. 759 paragraphs. It took a very long time to read, but then I had a 10-hour flight to India recently, so that's a great place to read a very long case. The allegations are on the screen. Here are the things that Getty said Stability had done. There are 5 main claims. They're all listed here: primary copyright infringement, secondary copyright infringement, database right infringement, trademark infringement, and passing off. Now, this next piece is absolutely crucial to understand why this, one of the reasons that the case went the way it did. The first and third claim were dropped before trial. The primary copyright infringement claim did not go to the court. It wasn't tried by the judge. It wasn't argued before the judge, and she gave no opinion on it. And because of that, the database right infringement claim was also dropped. Now, the reason it was dropped is because Getty could not find evidence to prove that the copying had taken place in the United Kingdom. It was a fundamental part of the primary copyright infringement claim. Try as they might, they couldn't find the evidence to support that. So those issues were dropped, and the trial proceeded with just the second, fourth, and fifth claim. One of the really important opening arguments, which spans a huge chunk of the judgment, actually paragraphs 99 to 133, is just who was responsible for making Stability AI available in the United Kingdom. Now, you could actually download it directly if you wanted to, but for the most part, most people accessed it through other systems, typically Dream Studios, Hugging Face, and GitHub. Getty's allegations, which span many pages, I've summarised into 2 paragraphs. They're on the left, and Stability's response is on the right. Getty say that we accept that it was made available through other platforms, but we think that you, Stability AI, we think you were the driving force behind those platforms and behind those disclosures. Stability say, well, actually, we disagree with that entirely. We don't think we released it. And yes, we did give it to other partners like Hugging Face and GitHub and Dream Studios, but that was a collaboration. It was a collective effort where the other parties were just as responsible as we were. So for the purposes of the tortious elements of the claim, it wasn't just us. We weren't the driving force. Others were involved too. The judge's conclusions are on the page here. I won't read the whole paragraph, but essentially she says, I agree with Stability. I don't think that they were exclusively responsible for this, which is an early loss in this very bizarre game of football, 1-0 to Stability on the who was responsible for making it available in the jurisdiction point. That takes us to issue 2. Remember, issue 1 was dropped, the primary infringement claim, and we have a secondary infringement claim. By the way, the numbers in the square brackets on the screen are just the citations to the paragraphs in the judgment, so you can go away at your leisure and read across the bits that you find most interesting. The issue the court had to decide was, has Stability infringed copyright in the UK by bringing an infringing copy of Getty's proprietary work into the country? Getty's allegations can be summarised into this paragraph. We think you've committed a breach of Section 22 of the CDPA, which, for those who aren't sure, is the Copyright Design and Patents Act 1988. Stable Diffusion, which is the name of the AI program, we think that's an article, and we also think it's an infringing copy. Stability AI say, well, look, on a point of technicality, we don't think an AI program can ever be an article or an infringing copy within the meaning of that act. if you're not sure what that section says, here it is. The copyright, literally section 22 says the copyright in a work is infringed by a person who, without license from the rights holder, imports into the United Kingdom an article. That's a very important word, which gets a lot of argument in the case. They import an article which he knows or has reason to believe is an infringing copy of the work. Infringing copy is an equally important term, gets a lot of argument in the case. What is an article for the purposes of section 22? Getty take a very expansive and purposive interpretation. They say, well, look, an article is basically anything, and it can include the model weights to an AI program. Repeated exposure to the training data fundamentally alters how the weights work, and there's nothing in the legislation that prevents an article from being an intangible or ephemeral thing. Stability go the other way. They go for a very literal, concrete approach. They say, look, an article has to be a tangible object. Intangible things and abstract information were never within Parliament's intention when this Act was created. The judge thinks about all this, and she concludes that Getty are right. An article should be anything which is an electronic copy, and it can include intangible forms. So far, so good, you might think. But there's more coming. What is an infringing copy? Well, Stability take the lead on this. They say, look, even if an article can be an intangible thing, and you get the gist from reading the case that they kind of think it will, for a thing to be a copy, there must be a reproduction of it. It must be a literal thing. If you think about the words infringing copy, it must mean that there is something we can compare the original to and say, well, that's the copy of it. This is so central to Stability's case. And they say, look, we don't think there's anything in an AI model weights that is an actual copy of anything. The model weights themselves are there, but there is no copy of the infringing item there. Getty say that Stability are obviously wrong, and they say that actually you have to take an expansive interpretation of infringing copy. You should adapt the interpretation of the statute to work in the 21st century by thinking that actually a model weight has in itself the essence or the ability to make the copy. The way it was made was infringing, and therefore the weights should be held to be an infringing copy within the meaning of Section 22. Now, we haven't spent a lot of time debating or analysing Section 27 of the CDPA, which is where you find the definition of infringing copy, because we just don't have time to tackle all of it in this short webinar. The judge said, and these are the critical points, if you wanted to look at anything, look at this. Paragraphs 599 and 600 of the judgment, she says, taking the specific facts of this case, is an AI model which derives the results from a training process involving the exposure of model weights to infringing copies itself an infringing copy? In my judgment, it is not. And there is the fatal blow. The scores on the doors are currently 2-0 to Stability. Now, that leads us to the trademark claim. And I have to say that as someone who was following this case closely, and I think as most lawyers and commentators were, the trademark claim was pretty much something none of us were paying attention to. Maybe it was just me, maybe everyone else was paying attention, but the trademark claim felt neither here nor there. Suddenly, on account of the copyright claim, it becomes very important. Getty alleged that Stability has infringed the trademark rights of Getty and all the other companies we've seen listed because Stable Diffusion allows images to be recreated with those watermarks. Stability say that no, we didn't do that. You can't prove that it really happened, and most of your evidence actually arises from manipulation of the process. There are a few emails where some pretty scathing comments come to not really help Getty's case at all. The email from Bill Kushik, who's a Stability employee, says we're getting lots of watermarks in our testing guides, and an email from Hugging Face back to Stability around about the same time says, look, if we use any prompts with the phrase vector art, we're constantly getting iStock images watermarked back. This probably isn't the desired result. All of that shows that on any reading, Stability had a pretty good understanding that watermarks were appearing in early versions of of stable diffusion. Section 10.1 of the Trademark Act is on the screen. A person infringes a registered trademark if he uses in the course of trade a sign which is identical to those for which a mark is held. Here are the allegations again. Stability is saying, look, you are reproducing our trademarks. Now, this is Getty are arguing that Stability's response is fantastic. They say the AI tool is just a tool. We aren't the ones making the infringement. The person who puts the prompt in and creates the image, that's the one who's really doing the infringing. It isn't us. It's the user. What a neat argument. The judge looks at it and gives it short shrift. In paragraph 345, she says, I agree with Getty. I reject Stability's submission that for each of the actions, it is the user and not Stability who's wholly responsible for conditioning the circumstances when the outputs are generated. So, for those who are interested in the technicalities, there are the results. But really, is this any win? It only relates to very specific historic uses, but technically it's 2-1 on the score. And to wrap up, a passing off claim was made. Here are the features of a passing off claim. Stability basically say we're not going to in any way concede passing off just because you won on the trademark claim. And actually the judge is pretty scathing on this. She says, look, the issue of passing off has just not been properly argued before me, so I decline to address it. Getty has succeeded in part on its trademark claim, but I do not see that the claim of passing off adds anything to my findings. I gave the parties the opportunity to make further submissions, but they didn't make them. So the final scores on the door are 3-1 to Stability. Let's come back into the room there, and we're going to talk to Ben about this, because in this case, my first question to you, I think, would be: Is this case limited to its facts? Do we just take away from it very little and say, look, that was a weird moment in time? Or actually, is it creating some kind of precedent that we should be thinking about, is setting the direction of travel for future cases?
So I think I start off by saying, in terms of the precedent that this case sets, I think it was a very well-reasoned, as you point out, very long judgment, which I have no beef with whatsoever. I think ultimately the most important claim by far, even before the primary infringement claims were dropped, is the secondary infringement claims. And ultimately that came down to a technicality. If you look at the reason why Getty failed on that claim, it was because the model was found not to be an infringing copy on the literal definition of copy. Weighed against that, you look at Article 27, which you mentioned briefly, of the CDPA, and this says that an infringing copy is an article whose creation in the UK would have infringed UK copyright law. So we have this sort of tension, which is arising because the law was created in 1988, and in those days there was no reason to anticipate any situation where something that is an infringing copy wouldn't also be a literal copy. And I guess the point I'm making there is that relying on very old cases, or very old law, for in a new technology area can lead to some sort of arbitrary, potentially strange outcomes. And I think that that's what's happened here, and really it doesn't reflect the sort of intention of the legislator. And we need, in order to have good, safe precedent, we really want an outcome which does reflect the intent of the legislator. So I think that's where it should go.
One of the really interesting things about the judgment is that the trademark claim became so important once it became clear where the judge was going on the secondary infringement issue. Do you think the trademark claim is? Do you think they should take any joy in the trademark claim? Because Getty, when Getty published their press release on the case, they were like, "Oh, we won," because we won the trademark claim. But on any reading of this, it doesn't look like a win. It doesn't feel like a win. It doesn't smell like a win. Is it a win?
I mean, I think Getty had to make some PR out of this, some positive PR out of it, and the trademark claim was the only thing they had as an option. In reality, it's not a win at all. you had the scores up on the doors, which were 3-1, which, if this were a Premier League football match, we'd say that's a firm beating. But I think that doesn't reflect the level of battering this really was in the court by stability. Really, the judge made the point that whilst technically Getty wins that point, that the scope of the infringement is so narrow. It's only, there was no way of knowing how the scale or the number of instances of this kind of infringement, watermark infringement, that had happened in the wild. And because of that, the scope is really limited to just the examples given in the case. And it's, it's also quite limited because there's only a very small number of outfits which operate in the way that Getty does, and maybe Shutterstock and a couple of others, which put images in public with watermarks, and I think it's largely irrelevant to a lot of other companies.
Do you think then that do you think this case is showing the judiciary's desire not to interfere at all? We can move in a moment towards future of law, government consultations and policy, but if someone walked into your office today that you've never met and said, "Hey Ben, look, I'm a rights holder, I want to try and protect my rights from AI programs scraping and infringing all of my content," what would you say to that person now?
Well, I would say that if they had a strong belief that this was being done in the UK, then UK law is still, in my view, fairly clear that training an AI model on copyright works would be infringement. So if they said we're doing it, that we think someone's doing this in the UK, then yeah, I'd say go ahead with your claim. If not, I would probably say you're going to need to sit back and see where the law goes on this.
That feels like a really good place to talk about the direction of travel, because for those of you who are avid viewers of the AI and Data Show, hi Mum, you will remember that Ben was with us back in February when Ben and I debated with Phil Bilney, who's not here today, the then consultation, which was the government's consultation regarding the change to copyright law to permit AI model training. And Ben and I were on opposite sides in that debate. One of the things that we spent a lot of time talking about was the government's desire to create this thing called a text and data mining exemption. The silence has been deafening from central government about what is going to happen next. We sit here in December having responded. There was a joint response from Cripps, EIP and a few others to that consultation. We have heard very little, if anything at all, about the direction of travel for that. In the light of this case, is this the time for a renewed call for some intervention by government to tackle the issue of rights holder issues regarding AI model training? And if so, what direction should it go?
Sure. I think that the government is going to have to step in and do something here. At least insofar as they need to make their intention clear. As I was saying, we're relying on very old law at the moment, and I think the government needs to say what its intentions are in relation to AI. In terms of what was previously proposed in the copyright consultation, they were looking to mirror the EU's text and data mining exception, which, for those not familiar, it's part of the EU's Copyright and Digital Single Markets Directive. Basically says that you can use copyright works. You can do automatic analysis of copyright works, provided that the rights holder hasn't explicitly reserved their rights or opted out. There's been quite a lot of criticism of the EU's law, or at least its application to generative AI, partly because when this law came about, generative AI wasn't a thing. And it was more for scientific research or getting insights from big data. It seemed a strange fit to put this to, something which like generative AI, which potentially, competes in the market and so on. And also the fact that many have pointed out and felt the realities that actually this notion of reserving your rights or opting out has still not been standardized and is potentially unworkable. So my view is that the government needs to do something, but it's not to follow in the EU's footsteps, which I think it's so controversial in the EU at the moment that they're having debates now as to whether or not to revoke, or at least to make clear that it doesn't apply to generative AI. I think that really we are at a time and a place where the Wild West period of generative AI has to stop, and we need to move from the extractive and exploitative world set in motion by Sam Altman into something that is sustainable. In other words, we need to move from, to use the analogy, we need to move from Napster towards Spotify. In order for that to happen, there needs to be support for collective licensing mechanisms, potentially being able to charge at the point of scraping, which is something that the US company Cloudflare has been working on. Support for individual licensing deals between, for example, big media companies and AI companies. It's probably a whole host of different things which are needed in conjunction together to make this work in order to make it viable. But ultimately, the government needs to support this, and it needs to be supported by strong copyright law, because otherwise there's always going to be a way, the AI companies are always going to find a way around it. So I think that's the direction that we need to be moving in. The UK, why should the UK be the one to be doing this? I think that, where is the UK a big leader? We are in creative industries, media, news, as well as law. And I think that this put the UK in a good position to be the first to really support this new world, which I believe that the industry has to transition to.
Do you think, were you disappointed when you saw the decision from Stability and Getty?
I was a little bit disappointed, but I wasn't surprised. I think it was. I think people sitting in sort of my position were hopeful but not optimistic that the secondary infringement claim would succeed. And like I say, I think whichever way it went, I think the government really has to say what they want to happen anyway. So it's.
I would echo that entirely. I felt that the outcome was no surprise to me. Reading the case as well, you get this vibe, and I don't mean to offend anyone by this, that it wasn't the best prosecuted case. That actually, there are whole moments in this judgment where criticism is levied at the way that Getty has gone about presenting its case. And actually, it may have gone differently had they have done it. The most obvious piece of evidence for that, but by no means the only one, is the dropping of the primary infringement claim so close to trial. It did feel, it didn't feel like a surprise as to the outcome. On the issue around where the government takes us next, I think one thing that would be very interesting to see is, I don't know if you agree with me on this, but it'd be interesting to see if the government gives us some indication, even around timelines, because we don't even have that at the moment, as to when they're going to start giving industry some kind of indication about what they do with this. Now, I think my take on it has been slightly different to yours, in the sense that I actually have a lot of sympathy with the rights holder view, particularly from the issue of natural justice. If I were a rights holder and I've gone to the trouble of protecting all of my rights and creating an IP profile portfolio, only then to have the rules changed around me, I would understandably feel pretty aggrieved about that. The bit of me that has a slightly big picture take on this, and it's similar to what Richard Susskind said when he was on the show back in July, is just whether actually the best thing for the UK is to water down some of its rights protection in order to enable ever increasing of AI, which is perhaps the more significant thing from a geopolitical superpower point of view. But would you disagree with that?
Well, I think there's two ways that think that there's two paths that will, one of which will be followed now globally. So this is my sort of big picture take on it. We've been living in a world where we're used to an open internet and free access to things supported by an advertising model, basically, and that has been brilliant for disseminating information and for a lot of the world we live in today. If we think that is still valuable and we want the open sharing of content, then I think that you are going to have to find a new way to be able to. You need to find a way that content creators are remunerated for their works being used by AI. If that that needs to be backed up by the law. If that doesn't happen, then we're going to move it into a closed walled garden version of the internet where everyone closes down. There won't be so much open sharing, and AI companies are going to have to license anyway to get the access to the content because it's going to be behind paywalls and things. So either way, the AI companies are going to have to pay for content soon. What is happening at the moment is unsustainable. Can't continue. I'm certain of that. Whether we are able to maintain some of the openness of the internet at the moment really comes down to what happens with the law. And I think that's where I'm coming from.
Well, that feels like a really good place for us to wrap up. Thank you very much to Ben Mading, partner at EIP, for coming in to join in our digest on all things Getty Images and stability. I should add that at the time of broadcasting, we don't believe that there is any plan for this case to be appealed. That obviously is a lot to appeal. They certainly could go after the infringing copy argument into the Court of Appeal, but as we are broadcasting, we don't know if that's going to happen. Now, it was nearly the end of the show, and we end every AI and Data show by introducing our wonderful and amazing AI elves who spend lots of time behind the scenes doing loads of research. And it's a pleasure to welcome for the very first time, Melin. Welcome to the AI and Data show. And you've already seen Amy today, so Amy, I won't introduce you again because you've just been on the show. You're just hanging out all the time here, like you're a full timer now. No, you've been looking at all kinds of things that AI might be doing in 2026. Why don't you tell the beloved viewer a bit more about what you think?
Yeah, of course. So one of the main forecasts that we believe we will see in 2026 is multimodal AI. So multimodal AI is technology that can understand and combine text and images and audio and video and sensor data within one model. This then in turn creates a richer and more human-like understanding and goes far beyond what single modal systems can do. So in 2026, multimodal AI will develop much like what we have seen ChatGPT do. So we already know that ChatGPT can read text and interpret images and understand audio all in one conversation, and we are expecting for this to be much more standard across different platforms as well. One of the sectors that I believe will benefit the most from this is the healthcare sector, and that's because by combining scans and lab results, clinician notes and wearable data, it means that multimodal AI can support earlier diagnosis, more precise treatment, and also reduce the administrative burden that clinicians have as well. Now, of course, there will be some setbacks. It's expected to have a few challenges, and some of those are the heavy computing demands and also ensuring trust and privacy when handling sensitive information.
Thank you, Megan. Amy, what amazing things do you think AI will be doing in 2026?
Yeah, so I think agentic AI will see a massive rise next year. Even Copilot agrees with this. So even Copilot, the Copilot. So I think the biggest difference between current models is that agentic AI takes initiative, whereas current models like ChatGPT wait to be prompted a question before they start working. So I think this will expand into all areas, so business and personal. So for business, this could be like warehouse automation or converting doctor's notes into patient-friendly summaries. And for in your personal life, this could be grocery ordering or calendar management. And I think the most likely affected industries will be transportation, healthcare, and the financial services. So I think there might be more like tailored AI, which are specific to these industries. But again, it raises issues about privacy and who's accountable when things go wrong.
There are lots of fascinating issues that agentic AI raises. We should definitely cover them at some point in the future. Not least one of them, which is if you instruct the agent to go off and do things for you, are you giving that agent legal agency for you? Can it enter into contracts on your behalf? Can it accept a cookie banner on your behalf? Can it accept terms and conditions on your behalf? All of that stuff I think is fascinating and merits its own debate. I think for looking forward to 2026, one of the things that obviously jumps off the page at me beyond the tech development is just watching very closely what happens with the EU's digital reform package, this idea that it's going to simplify lots of core and important laws, particularly GDPR, particularly the EU AI Act. This feels like a really significant development and one that I know a lot of people are watching closely. So certainly I'll be watching that. And of course, the handing down of the judgment in the TikTok case. Those of you who've been following the show for a long time will know that we've been following that case very closely. It's of significant importance to most of our businesses because it's directly relevant to lots of data protection issues. We haven't had that judgment in 2025. Kind of hoped we would have, so we could have done a digest for you. But instead, we had Getty Instability AI, which is easily a case of more profound significance for all of the UK industry. That is the end of the show. It's 1:15. Thank you very much to everyone who's tuned in, and to all of the people behind the scenes who have made the production possible. I'd like to thank all of our guests. I'd like to thank Ben Maley for coming on. And I'd like to thank Jamie Suskind, Richard Suskind, Sir Robert Buckland, and Anya Proops, who've also been guests in previous shows this calendar year. It's been great hanging out with you. Wish you all a very Merry Christmas, and we'll hopefully see you in 2026.